Welcome to the City and County of San Francisco's Office of Labor Standards Enforcement presentation on the Family-Friendly Workplace Ordinance. This presentation is brought to you by the team listed here, and I, Beverly Popek, will be taking you through this recorded presentation. A quick review of the legislative history of the Family-Friendly Workplace Ordinance, or FFWO. In October of 2013, the San Francisco Board of Supervisors passed the Family-Friendly Workplace Ordinance. In March of 2022, the San Francisco Board of Supervisors amended the ordinance, and later that month, the mayor signed the amendment. The operative date for the amendment is July 12, 2022. Employee rights. The Family-Friendly Workplace Ordinance gives covered employees the right to a flexible or predictable working arrangement to assist with caregiving responsibilities for 1. A child or children for whom the employee has assumed parental responsibility. 2. A person or persons with a serious health condition in a family relationship with the caregiver. 3. A person who is age 65 or older and in a family relationship with a caregiver. Family relationship means a relationship in which a caregiver is related by blood, legal custody, marriage, or domestic partnerships as defined by the San Francisco Administrative Code, Chapter 62, or the California Family Code, Section 297. As either may be amended from time to time to another person, such as a spouse, domestic partner, child, parent, sibling, grandchild, or grandparent. The amendment has led to a few significant changes. First, the Family-Friendly Workplace Ordinance used to give employees only the right to request an arrangement with a guaranteed process, but there was no enforcement regarding the employer's basis for denial. As amended, an employee now has the right to a flexible or predictable working arrangement unless an employer is able to demonstrate an undue hardship. The amended law also expanded the scope of an arrangement to telework. We will unpack both of these changes in detail later in this presentation. Covered employer. Not every employer must follow the Family-Friendly Workplace Ordinance, only what we refer to as covered employers. To be a covered employer, your business must employ 20 or more employees, and these employees can be anywhere in the world. If you go to the OLSE webpage for the Family-Friendly Workplace Ordinance, you will find the rules implementing the Family-Friendly Workplace Ordinance. Look to Rule 1.2 for assistance in determining if you are a covered employer, particularly if you have fluctuating employees. In addition, a covered employer must have a business location within the geographic boundaries of the City and County of San Francisco. A business location is any physical space used for the business to run its operations. Now that we understand who's a covered employer, let's look at covered employees. Not every employee is covered. The law established requirements to be a covered employee and entitled rights provided for in the Family-Friendly Workplace Ordinance. An employee must have worked for the employer at least 6 months and work at least 8 hours per week within the geographic boundaries of San Francisco. Of note, a new aspect of the law created in the amendment is the geographic boundaries of San Francisco, and they were expanded to include those teleworking, but that comes with some guardrails. So what about employees who telework? Let's unpack this telework expansion. An employee is covered by the Family-Friendly Workplace Ordinance if they're assigned to a San Francisco business location at the time the request is made, regardless of where they're physically working. An employee is not covered by the Family-Friendly Workplace Ordinance if they were never assigned to the San Francisco office. So see Rule 2.3 when determining where a remote employee is assigned for the purposes of the Family-Friendly Workplace Ordinance. An employer should consider factors including, but not limited to, the location of the employee's computer, manager, teammates or coworkers, personnel file, where the employee worked prior to the beginning of telework, and or employee's proximity to the business location. Is this a covered employee? With this information in mind, let's take a look at an example to figure out and learn more about covered employees. You can see and find this information on Rule 2.3, example number 1. An employer has 3 offices in San Francisco Bay Area: San Francisco, Burlingame, and Hayward. The employee works from their home in San Mateo, and if they were to work on site, the employer would assign them the work in the Burlingame office. In other words, the Burlingame office, not San Francisco office, would be the office the employee is assigned to work on site or in person. With this information, the employee is not covered by the Family-Friendly Workplace Ordinance, even though they work for an employer who has an office in San Francisco. Now, here are 2 more examples to better understand how the law applies to telework and covered employees. You can find this example in Rule 2.3, example number 2. Let's turn our attention to the left-hand side of the slide under employee number 1. Employee number 1. An employer has a physical office in San Francisco. In 2019, employee number 1 on our slide worked at the employer's San Francisco office. Then, in 2020, the employee began to telework and moved to Oregon. That same employer has offices in California, Colorado, and New York, and allows some of its employees to telework full-time. This employee, employee number 1, is covered by the Family-Friendly Workplace Ordinance because they are assigned to the San Francisco office for the purposes of the ordinance and determining a covered employee. Now, let's turn our attention to employee number 1's coworker, employee number 2. Employee number 2 lives in Nebraska, was hired in 2021 directly into a telework position, and never worked in or out of the San Francisco office. Given this information, employee number 2 would not be covered by the Family-Friendly Workplace Ordinance, even though the business has a San Francisco office. Of note, if employee number 2 were to assert that they are assigned to the San Francisco office rather than the geographically closer office in Colorado, they would have to provide supporting evidence in support of their assertion. Now, to comply with the Family-Friendly Workplace Ordinance, it's important to have a detailed understanding of what the requirements are. Let's go through them. Number 1, upon receiving a completed written request, review to determine if you can provide the employee with a flexible or predictable work arrangement to assist in caring for their children, family members with serious health conditions, or family members 65 or older as requested. 2, if you do not agree to the request, engage in a good faith interactive process to determine a mutually agreeable arrangement. 3, if unable to accommodate the request, notify the employee in writing explaining the undue hardship determination and the employee's right to request reconsideration and file a complaint with the Office of Labor Standards Enforcement. This is a flow chart of the Family-Friendly Workplace Ordinance request process. This chart is available on our webpage, and I will now take you through this process over the following several slides. So let's start at the beginning, and you can refer to Rule 3 for more on this stage of the process. First, the employee submits a completed written request for a flexible or predictable working arrangement, which could include arrangements such as telecommuting on certain days, having a certain day off, or starting their shift a half an hour later. If the employee makes the request verbally, the employer must tell that employee that a written submission is required. The written request must explain how the requested arrangement is related to the employee's caregiving duties. Saying I need Tuesdays off is not enough. An employee must explain why they require the arrangement and be specific as to the terms of the request, including how long they expect to require the arrangement. While some requests will clearly have an end date, such as a school year, others may be less definite, such as caring for an ailing parent. Employees should submit their request at least 21 calendar days before the requested start date, since the law affords the employer 21 days to issue a determination. But there are times when an employee may not have 3 weeks' notice of their caregiving duties and the need for an accommodating arrangement. In that case, we encourage employers to make best efforts to issue a determination as quickly as possible. Once the employer receives the completed written request, the clock starts. The employer has 21 days to issue a determination. That time frame may be extended if both the employer and employee agree, confirming in writing. An employer may find that the employee's attestation about their caregiving duties is sufficient. However, an employer has the right to request verification if necessary, but within certain parameters. Let's unpack the employer's right to request verification. You can refer to Rule 4 and 4.1 for these examples. Let's say an employee requests to work 7 a.m. to 3:30 p.m. on Tuesdays so they can take their grandmother to a standing medical appointment that she is unable to get to without assistance. The employer may ask the employee to provide a note from the healthcare provider confirming the weekly appointment and its date and time. However, the employer may not ask about the reason for the appointment or require verifications from employees' family members that they are unavailable to take their grandmother to this appointment when there's no basis to believe that the employee's attestation is invalid. If you have a demonstrable reason to believe the employee's attestation about their caregiving duties is invalid, then you may be able to ask for additional verification. However, you cannot ask for information that would require the disclosure of private medical information. For example, if the employee recently requested the same schedule on Tuesdays so they could participate in their weekly golf league at Golden Gate Park, but was denied, and then requests the family-friendly workplace ordinance arrangement soon after, the employer has a valid reason to believe the family-friendly workplace ordinance request is not valid and therefore may require additional verification to support the request. Again, the requested verification must be within reason and not require the disclosure of medical or privileged information. How can an employer distinguish between a regular scheduling request and a family-friendly workplace ordinance request? Let's look at this example. Regular scheduling request or family-friendly workplace ordinance request? This example can be found in Rule 3.3. An employee receives their schedule every 2 weeks and is required to make any scheduling requests on the Friday before the schedule is posted. On the first of the month, the employee requests not to be scheduled for the night shift on the 12th of the month. This is the request from the employee. The manager hears from a coworker that the employee's request is to attend his son's dance recital. Is this a valid family-friendly workplace ordinance request, or is this a regular scheduling request? The answer is the employee's request is not considered a notice of the employee's need for a flexible or predictable working arrangement, since he did not expressly disclose his need is due to his caregiving responsibilities. Also, his request was not made in a timely manner, for example, affording the employer 21 calendar days to respond. Therefore, this request should be regarded and addressed as a regular scheduling request. If the employer agrees to the requested arrangement, they should confirm in writing and issue that determination within 21 days of receiving the request. But what if the employer does not agree to the request? Let's say the employer believes that there is an alternative arrangement that could meet the employee's caregiving duties, but be less impactful on operations. Then the employer must engage in an interactive process with the employee to discuss an alternative arrangement. Remember, you have to issue a determination within 21 days, so you must timely engage with the employee to discuss alternatives that meet their caregiving responsibilities, but better suit your business operations. The discussion cannot be for show, and the employer must have the discussion in good faith and not obstruct the process. Part of that good faith is doing a real analysis of the employee's duties and role and making best efforts to find a workable arrangement. While an employee may be displeased that they are not receiving their arrangement of choice, as long as you provide an arrangement that allows the employees to meet their caregiving responsibilities, you will be in compliance with the family-friendly workplace ordinance. So let's look at this interactive process. And you can find this example in Rule 5.2. And this is the example. An employee requests to telework on Wednesdays due to caregiving responsibilities, but their team has a mandatory in-person team meeting on Wednesdays. The employer does not agree to allowing the employee to miss these mandatory meetings. What should the employer do next? The employer must contact the employee in a timely manner without unreasonable delay to begin the interactive process. Examples of reasonable delay would be the employee being on vacation or the employer being at a work conference. The employer must have a conversation with the employee about alternative accommodations that would support the employee's need to meet their caregiving responsibilities. During their discussion, the employee explains that they need to be home by 3 p.m. The employer could propose that the employee work on site until 12 p.m., thereby attending the team meeting and then telework the remainder of the workday. As a best practice, the employer should document their conversations with the employee. If the employer and the employee cannot reach an agreement that accommodates the employee's caregiving duties, the employer can deny the request, but only if they can prove that approving an arrangement that meets the employee's caregiving duties would cause undue hardship. An employer is not required to alter or impede their business operations in a manner that would cause significant expense or operational difficulty. However, the employer must be able to demonstrate that significant impact amounting to undue hardship. Undue hardship is the only reason for a denial. Let's look at the definition of undue hardship. It is causing the employer significant expense or operational difficulty when considered in relation to the size, financial resources, nature, or structure of the employer's business. The denial must be in consideration of the most current arrangement the employee has requested, whether it be the original request made or the altered request that resulted from the interactive process. If an employer asserts that it can only comply with some of the requested arrangement, for example, the employer can reduce hours but not allow the employee to begin work earlier in the day without undue hardship, then the employer should comply with those provisions of the request and demonstrate undue hardship for the part of the request it cannot accommodate. Each situation is unique and subject to an individualized analysis, and employers should consider their circumstances in determining whether they can assert an undue hardship. The burden of proof is on the employer. Now, let's look at some examples that illustrate what a showing of undue hardship may or may not look like. This is example number 1. Can the employer deny this request? And this has to do with a store clerk and caretaker responsibilities. You can find this in Rule 6.4, Example 1. An employee works an 8-hour shift from 9:30 a.m. to 6 p.m. as a store clerk. The employee requests a predictable schedule to begin work at 7 a.m. so they can return home in time to administer medication to their 76 years old grandmother. The employer's store is open from 10 a.m. until 6 p.m. Now, apart from preparing for opening as a store clerk, the employee does not perform any duties that can be accomplished when the store is closed, and the requested schedule or reducing the employee's hours will lead to insufficient coverage during store hours. After receiving the request from the employee, the employer must follow the family-friendly workplace ordinance process, which includes engaging in an interactive process where both parties timely meet to discuss alternative arrangements. The employer should consider the requested arrangement, but may approve an alternative arrangement that effectively meets the employee's caregiving responsibilities. The employer should analyze the functions and purpose of the employee's position in relation to the operations of the employer. With the information provided in the example, the employer can likely demonstrate an undue hardship and deny the requested arrangement because of a detrimental effect on the employer's ability to meet customer or client demands. Let's take a look at another example. Can the employer deny this request? And this one has to do with a office worker and childcare responsibilities. You can find this one in Rule 6.4, example number 2. In November, an employee requests to work a 4-day-a-week, 10-hour-a-day schedule until the following August to provide care on Fridays because their child's preschool reduced operations to Monday through Thursday only. The employer does not hold any mandatory meetings on Fridays, and the employee holds a position that is not public facing, and all essential duties can be performed Monday through Thursday. After receiving this request from the employee, the employer must follow the family-friendly workplace ordinance process, including engaging in the interactive process if they believe they cannot accommodate the request as stated. Now, even though the employer prefers everyone to work a Monday through Friday, 8 hours per day schedule, and is concerned that others will want to work this schedule, they would not be likely to be able to demonstrate undue hardship based on preference and this concern. However, if an employee's requested schedule would require the employer to pay the employee overtime wages pursuant to the California Labor Code, the request could be denied due to significant identifiable costs directly caused by the requested arrangement. Now, in this scenario, the employee's duties can be completed on a Monday to Thursday 410 schedule, and the employee is exempt from overtime wages. So the employer cannot demonstrate a significant financial or operational impact from allowing the employee to work this schedule. If after approving the schedule, the employer notices a decline in productivity, they can revisit the approval of the schedule per the ordinance. Here's another example. Can the employer deny this request? And this is a relocation request. And you can find this in Rule 6.4, example number 4. An employee requests to work at the North Beach location instead of the Outer Sunset location of the employer's business due to caregiving responsibilities. There is a need for staffing at the North Beach location, but the employer is concerned that other employees will also want to request a change to the North Beach location. After receiving this request from the employee, the employer must follow the Family-Friendly Workplace Ordinance, which includes the interactive process where both the employer and employee must meet to discuss alternative arrangements. The employer may approve an alternative arrangement that effectively meets the employee's caregiving responsibilities, such as the employee working part-time at the Outer Sunset location and part-time at the North Beach location if such an arrangement would allow the employee to meet their caregiving responsibilities. For this specific example, the employer would not likely be able to demonstrate undue hardship based on their concern. An employer can use objective criteria to address multiple family-friendly workplace ordinance requests, such as seniority, if multiple requests are made at once. If the employer cannot demonstrate undue hardship, they cannot deny the request. If the employer is able to demonstrate the requested arrangement would cause undue hardship, and there is no alternative that would meet the employee's caregiving duties without causing undue hardship, the employer can deny the request. The denial must be in writing and contain the following. 1. Explanation of the basis for the denial and undue hardship. 2. Notification to the employee of their rights to A. Request a reconsideration by the employer under Section 12Z.6 and B. File a complaint under Section 12Z.10, including a copy of the notice under Section 12Z.8. The employee has the right to request reconsideration by the employer as long as they make the request within 30 days of receiving the written denial. The employer must then meet with the employee within 21 days of receiving the request for reconsideration and make a true reconsideration of the request based on the information provided. The employer must issue a final decision in writing within 14 days of the meeting. An employee may file a complaint with the Office of Labor Standards Enforcement if they believe the denial was inappropriate. The employee must have either received a response to the request for reconsideration or the time frame for the employer to respond elapsed without a response. The Family Friendly Workplace Ordinance has noticing requirements every employer must be aware of. Rule 11, Family Friendly Workplace Ordinance Notice or Poster. OLSE mailed all registered businesses with the City and County of San Francisco a copy of the poster. A printable version can be found on the Family Friendly Workplace Ordinance webpage in English, Spanish, Chinese, and Filipino at the address listed on the slide. If the language spoken by 5% or more of the workforce is a language other than those listed, the employer shall be responsible for translating the form and providing it to the workforce. The employer must provide employees with the Family Friendly Workplace Ordinance request form or comparable form within a reasonable time after the employee inquired about a Family Friendly Workplace Ordinance accommodation. There is a Family Friendly Workplace Ordinance form on the Family Friendly Workplace Ordinance webpage. Give a copy of the Family Friendly Workplace Ordinance form to current and new employees, and employers must add a policy to your employee handbook when your handbook is updated. I will not go into detail about the enforcement procedures, but instead refer you to read Rule 12 and its subparts to understand the process. To wrap up, let's review some best practices. Employers must engage in an interactive process with the employee to attempt in good faith to determine a flexible or predictable working arrangement that is acceptable to both the employee and employer. The interactive process is defined as timely, good faith discussion, either orally or in writing, between the employer and employee. And feel free to meet and discuss the request with the employee, but everything should be memorialized in writing. Keep good notes, emails, analysis, calculations. Employers must save all documents involved in the Family Friendly Workplace Ordinance process for at least 3 years. And remember that each situation is unique and subject to individualized analysis. For information and to see the documents I discussed in today's presentation, please visit our website listed here. Thank you for watching this presentation. If you would like to contact the Office of Labor Standards Enforcement or to review other labor laws and requirements, please visit our OLSE website.